Roger Lin et al. Versus United States was brought in 2008 and asserted that elections in Taiwan were illegal for the President of the Republic of China in the territory owned by the Emperor of Japan, now being under de jure occupation by the United States and de facto occupation by the Chinese colonial regime, under the name of the governing authorities on Taiwan, as an agent of the United States military government. Permanent occupation by the Chinese colonial regime on Taiwan should be deemed as an offense against the law of nations, the lawsuit claimed. Plaintiffs sought declarations that, one, the AIT's refusal to process the individual's appellant's passport applications wrongfully deprived them of their status as U.S. nationals and the attendant rights that go with that, and two, appellants, the plaintiffs at the time, are U.S. nationals entitled to all associated rights, particularly those flowing from the First, Fifth, Eighth, and 14th Amendments. The arguments presented in the U.S. District Court for the District of Columbia, that's Washington, D.C., before the Honorary Rosemary Collier were as follows. None of the Allies recognize any transfer of the sovereignty of Taiwan to the Republic of China upon the October 25, 1945 surrender of Japanese troops in Taipei. In the U.S. Senate-ratified San Francisco Peace Treaty of 1952, Taiwan was not awarded to China, and the Treaty of Taipei confirmed these arrangements. From an examination of the military history of the Spanish-American War cessions of Puerto Rico, the Philippines, Guam, and Cuba, it was clear, they argued, that the military government of the principal occupying power does not end with the coming into force of a peace treaty, but continues until legally supplanted. Plaintiff argued that prior drafts of the SFPT of Article 2B show that the Allied powers originally intended to give China sovereignty over Taiwan, then called Formosa, but later affirmatively changed their intention. The drafts dated August 5, 1947 and January 8, 1948 provided, quote, Japan hereby cedes to China in full sovereignty the island of Taiwan, or Formosa, and adjacent minor islands, end quote. By contrast, the final draft of the SFPT did not transfer full sovereignty in Taiwan and the Pescadores Islands from Japan to China. In consideration of the above, the plaintiffs argued, Taiwan has been occupied territory since the completion of the surrender ceremonies on October 25, 1945, and remains an occupied territory in the current era. The plaintiffs allege that this state of affairs has never changed. The United States remains the principal occupying power, holding sovereignty over Taiwan and title to its territory in trust for the benefit of the Taiwanese people. The lawsuit also argued that under the law of nations, Japan's sovereignty over Taiwan carries with it natural, inalienable obligations of sovereignty over Taiwan, and that accordingly, the Emperor of Japan still keeps the ownership of the territory of Taiwan, and the government of Japan still retains residual sovereignty over Taiwan. And this situation is in accordance with the doctrine offered by Mr. John Foster Dulles in a speech at the San Francisco Peace Conference held on September 5, 1952. The residual sovereignty which was applied to the relationship between Japan and the Ryukyus, or Okinawa, during the period the trusteeship system was exercised between April 28, 1952 and May 14, 1972. Recall again the trusteeship system set up by the U.S. over territories such as Puerto Rico, the Indian nations, and other territories of the U.S. The lawsuit argued naturalization of native inhabitants along the implementation of military conscription activities in occupied territories are in violation of the laws of war as recognized by the United States, in particular, the field manual describing the law of land warfare, FM 27-10, the law of land warfare. Under FM 2710, 359, Oath of Allegiance Forbidden, it is forbidden to compel the inhabitants of occupied territory to swear allegiance to the hostile power. Section 418, Labor of Protected Persons. The occupying power may not compel protected persons to serve in its armed or auxiliary forces. No pressure or propaganda which aims at securing voluntary enlistment is permitted. The occupying power may not compel protected persons to work unless they are over 18 years of age, and then only on work which is necessary either for the needs of the Army of Occupation or for the public utility services, or for the feeding, sheltering, clothing, transportation, or health of the population of the occupied territory. Protected persons may not be compelled to undertake any work which would involve them in the obligation of taking part in military operations. The occupying power may not compel protected persons to employ forcible means to ensure the security of the installations where they are performing compulsory labor. In no case shall requisition of labor lead to a mobilization of workers in an organization of a military or semi-military character. Now, according to the plaintiffs in Lin versus United States, the decision not to cede Formosa to China was a considered judgment. The final draft of the SFPT did not transfer full sovereignty in Taiwan and the Pescadores Islands from Japan to China. Instead, Article 23 designated the United States as the principal occupying power, with the government of the ROC as its agent. So what was the decision of the court? On March 18, 2008, the district court decision ruled against the plaintiffs, Dr. Roger Lin et al., holding that only the president can decide questions of sovereignty, declaring that it is a political question, declaring that who is a sovereign of a foreign country or territory is non-justiciable, thus not within the competence of the judicial branch. And the separation of powers with two other branches, Congress and the presidents, being the only ones who weigh in on treaties and sovereignty. Thus, the issue of Taiwan's status involves too many policy issues consigned to coordinate branches, meaning the other branches of government, Congress and the president. On appeal, on April 7, 2009, Justice Janice Rogers Brown affirmed that holding against the plaintiffs, holding that plaintiffs have been put in a political purgatory. Quote, plaintiffs have essentially been persons without a state for almost 60 years. The last completely clear statement of authority over Taiwan came from General MacArthur in 1945. One can understand and sympathize with plaintiffs' desire to regularize their position in the world, end quote. The court went on to hold that it is a political question as to how Taiwan is regarded, whether as sovereign, an independent nation, or as part of the ROC or PRC, but not within the competency of the courts to decide. The decision that it was a political decision came from cases such as Jones versus United States and Baker versus Carr, which held that who is a sovereign de jure or de facto of a territory is not a judicial but a political question. She found that the president had not acted. Quote, once the executive determines Taiwan's sovereignty, executive being the president, we can decide appellant's resulting status and concomitant rights expeditiously. But for many years, indeed, as appellants admit, since the signing of the SFPT itself, the executive has gone out of its way to avoid making that determination, creating an information deficit for determining the status of the people on Taiwan. Now, other cases that have come down at about the same time seem to take a different approach to decision-making of the president. In Boumediene versus Bush, the United States Supreme Court observes that during open hostilities, it can consider and rule on issues involving Congress, the executive branch, and the United States Constitution in respect to the handling of alleged enemy aliens directly threatening the United States mainland. Now, if that is the case, the appellants argued in Lin surely the interpretation of the SFPT and its legal effects upon appellants under the U.S. laws are properly within the court's purview or ability to rule. But the opinion distinguished that case, which involved the ruling on legality of detentions at Guantanamo Bay, stating that the case did not overrule the political question doctrine, because in that case they were ruling on de facto sovereignty questions, whereas in Lin it involved de jure sovereignty, that is, the very legal status of Taiwan, as opposed to how it was being treated in fact or in practice. The Lin court also distinguished other cases that might have provided support or ballast for the idea that the court could rule in favor of Taiwan. It distinguished cases involving the Philippines, finding that the Filipino population was entitled to the protection of the United States based on the United States sovereignty over the Philippines, referring to Rabang versus Boyd, a 1957 Supreme Court case. Later, Congress acknowledged, quote, the final and complete withdrawal of American sovereignty over the Philippine Islands, end quote. The Lin case was appealed to the United States Supreme Court, but the Supreme Court denied the case, refusing to grant a writ of certiorari, meaning it refused to take the case at all. It didn't say anything about it. So where does that leave us in the law? What is the law since then? Well, some cases since the Lin versus United States do have some bearing on our subject today. Zivotofsky, ex rel. Zivotofsky versus Clinton, a 2012 case, involved an act of Congress that required allowing a U.S. citizen to have Jerusalem listed as the place of birth on the passport. The court explained that, quote, the federal courts are not being asked to supplant a foreign policy decision of the political branches. Instead, Zivotofsky requests that the courts enforce a specific statutory right. Because the lower courts erroneously concluded that the case presents a political question, they did not reach the merits of Zivotofsky's claim. The court found there is no exclusive commitment to the executive branch of the power to determine the constitutionality of a statute. The judicial branch appropriately exercises that authority, including in a case such as this where the question is whether Congress or the executive is aggrandizing its power at the expense of another branch. The question was, is the Congressional act to require the Immigration Department to put Jerusalem on the passport, thus causing a lot of consternation among Palestinians and others who didn't agree with Jerusalem being part of the Israeli state. Sorry, I can't separate the pages here. And a lot of feathers got ruffled over the issue of sovereignty of Jerusalem. But does this interfere with the function of the president to make policy concerning Israel? That was the question. The court held that it did not and looked at precedents such as Morrison versus Olson, a 1988 case involving the power to discharge a person in office under the president. The Lin versus United States case is cited in the briefs before the Supreme Court in Zivotofsky, showing how important the Lin case is now in the jurisprudence in this area. The government argued that the Constitution showed a preference for the president to exclusively deal with who is the sovereign. It said, the Constitution's declaration that the president shall, quote, receive ambassadors and other public ministers in Article 2, Section 3, constituted a special power of the president. According to the Secretary, centuries-long executive branch practice, congressional acquiescence and decisions by the court confirm that the Receive Ambassadors Clause confers upon the executive the exclusive power of recognition. But the court rejected this, noting the Taiwan passport law and other instances where Congress shared some of the powers regarding issues of foreign states, even when it could cause political hackles to be raised or implicate sensitive foreign policy issues. The court upheld the right of Zivotofsky to have Jerusalem put on his passport as his place of birth. But it sent the case back down to the lower court, same court that Roger Lynn went in front of, to determine the case consistent with the ruling of the court. We call that a remand in the law. Just to show you how crazy things get in our system as much as anywhere else, the D.C. Circuit Court, court right below the U.S. Supreme Court, which had decided Lynn versus United States, held the act unconstitutional, the act that granted Zivotofsky the right to put Jerusalem on his passport, held it unconstitutional as intruding on the president's foreign affairs power. So it went back up to the Supreme Court and is now there to be decided this year. It's now called, of course, Zivotofsky versus Kerry, because he became the Secretary of State after Clinton left. Now, the Court of Appeals for the District of Columbia invalidated the law as unconstitutional, finding that Section 214 of the Foreign Powers Act, that gave the right of one born in Israel to have that placed on his or her passport, was an unconstitutional intrusion on the powers of the president. We'll see how this comes out in the coming term, but it seems likely that the court will reverse and find that Section 214 of the Foreign Powers Act does not violate the Constitution's separation of powers. Other case law involving the Alien Tort Statute, or ATS, a 1789 statute giving non-U.S. citizens the right to file suits for international human rights violations in U.S. courts, is the Kiobel versus Royal Dutch Petroleum Company case, a United States Supreme Court case from 2013. In that case, the U.S. Supreme Court struck down a suit in U.S. District Court against Royal Dutch Petroleum for environmental problems in Nigeria that prompted a protest and a military crackdown on Nigerian citizens. The court held that the action under the law of nations for preventing human rights abuses such as occurred in Nigeria and the corporation that allegedly aided and abetted these abuses did not provide a cause of action in the U.S. courts, where there is a presumption against extraterritorial application of U.S. laws. Citing the danger of unwarranted judicial interference in the conduct of foreign policy, the court said these cases should be allowed only with great caution. So even though norms of non-torture or other human rights abuses exist, this is not enough in and of itself to allow a claim in U.S. courts by a foreign national. What then are the lessons of Zivotofsky, Lynn versus United States, and these other cases? While Lynn held that since the president had not ruled on sovereignty of Taiwan, it implied that only the president is competent to act on that, Zivotofsky holds otherwise, finding that Congress has a role in the recognition of issues touching on sensitive political relationships, at least when it concerns matters such as passports. Courts will be cautious in exercising jurisdiction unless there is a clear intent from Congress to allow the claim, as in Zivotofsky, but not in the Royal Dutch Petroleum case. What then is the way forward? When considering what to do in the future on the issues that are of such great concern here to you, I would say that a three-part approach is in order. Use of the legal system, action before Congress or with members of Congress, which we call lobbying, and then use of the media, print and or movies, documentaries, and that sort of thing. Using a three-dimensional approach gives a good chance of greater awareness and possible action. So the TCG strategy that we would recommend is continued attempts in public interest litigation, which is most successful when it provides good human stories to tell about Taiwan. You've highlighted the amazing achievements of this country and its history, its challenges, its identity, and struggles as a people and as an influential island of the world. Combined with powerful legal arguments, TCG has at its disposal opportunities to continue to tell this powerful story of struggles and to uncover continuing injustices, whether it be in the area of human rights or elections or constitutional infirmities. These can be brought under the Taiwan Relations Act. and the requirements of compliance with monitoring by the State Department over elections, combined with the Alien Tort Statute, utilizing customary international law standards.